So good afternoon, ladies and gentlemen. Of course, it's been quite an eventful day. Please, can we hear me? I'm not sure what that is. Okay, great. So I said it's been quite an eventful day. I think this is about the fourth session for me today. And so this session is the last lap of the day. And of course, we are looking at cross-border, transfer of personal data and international best practices. And of course, today, joining me is a panel of distinguished experts drawn from different countries around the world, Nigeria, Singapore, and the Netherlands. Of course, this is with a view to giving us balance of the subject. So my name is Solomon Okedera. Of course, I'll be your moderator. And of course, so let's meet our panelists. So Hadabi, so we'd love to meet you.
Okay, my name is Adobe Olaim. I am the data protection and cybersecurity lead for Tax Tech. And our offices are here in Lagos, but we have a global reach with respect to the services that we provide.
Thank you so much. Pleased to have you. So Magdalena, let's meet you.
My name is Magdalena Jansa, and I'm GDPR and IPR legal advisor based in the Netherlands, and I am working for GIANT Association, which is providing internet and internet services for research and education networks.
Thank you so much. You're welcome. So joining us all the way from Singapore is Sanjeev. Sanjeev, good day to you today. Can we meet you?
Yeah, good day, everyone. Thank you for having me. My name is Sanjeev, and I'm the CEO of Comply Learn Private Limited in Singapore. And I provide consultancy and training in the space of cybersecurity and privacy. So that's about me for now.
Thank you, Sanjeev. Great to have you with us today. Well, I don't know whether Sonny is in the room with us. Sonny, are you in the room? I guess we're having some difficulty joining us, but we hope it can. Okay, yes.
Yeah, can you hear me?
Yes, Sonny, good afternoon.
Hi, good afternoon, Solomon.
How's Kano this afternoon?
I know it's great.
Great. So let's meet you. Want to know you, what you do, and the organization.
Oh, great. So my name is Sani Suleiman Sani, and I work with Paradigm Initiative, a Pan-African organization working to promote digital rights and inclusion across the continent. I'm a program officer, and I am also the contact person for business and human rights related activities in the organization. And it's good to be here. Thank you.
Yeah, it's good to have you too, Sonny. Okay, so in the next few seconds, we're going to go into the panel, properly. But before we do that, I need to let us know that if you have any questions, you can just point out your question. We will be able to take about 3 or 4 questions at the end of the panel. Then, of course, our panelists will give us their potential. Then we will actually call it a day. So, Adabi, let me start with you. Now, talking about transfer of personal data across borders, oftentimes quite a number of persons, including professionals, particularly given the fact that data protection field is still at its nascent stage on the continent. So people get to wonder, what does that exactly entail, and in what ways does this manifest when you're talking about transfer of personal data across borders?
Okay, thank you, Solomon. Okay, in practice so far, I think what we essentially see is where you're dealing with a group of companies that has different affiliates, across the globe, that you can have situations where data is transferred in that situation. But you also have to look at the unprecedented use of data storage solutions now with respect to cloud storage of information. That's another aspect where data is transmitted with or without the parties actually being clearly aware of how much is being sent out of the jurisdictional location. So those 2 specific areas.
Okay, so from experience and of course working on projects and all of that transactions, could you actually simplify and maybe illustrate I mean, instances that you can pretty much relate to, like, that an ordinary man on the streets can understand better?
Okay, so I think one situation I can give is something that happened recently. I had a client who was sharing information on the board of directors across the group. So that was one area where they had to actually take information, sensitive personal data, and share, including information around life group insurance. So they needed to have some medical records also shared across the entire group. So that is one scenario that can work out.
Okay, thank you so much. So Magdalena, let me come over to you. The truth is that when we are talking about cross-border transfer of personal data, one thing is what cross-border transfer of personal data means to a Nigerian is not the same thing in what it means to a Dutch person, because cross-border transfer of personal data from Netherlands to France may not be the same thing from Nigeria to Ghana. So will you shed more light what it means within EU and outside EU?
So from European perspective, from general data protection regulation perspective, whenever you are willing to share the data from Europe to other places, you need to apply GDPR. And of course, there are in chapter 5, there are reflected the rules for transfer. So of course, if you are transferring the data within European Union from the Netherlands to France, that's basically you don't have to worry. But if you want to transfer the data, for example, from the Netherlands to Nigeria, you will need to apply the rules for transfer. And those are that basically the first rule, we are checking whether there is adequacy decision. As for now, we don't have adequacy decision. If there is no adequacy decision, we are checking as a company if you have, for example, binding corporate rules that allow you to share the data within this different location. But again, if there are no binding corporate rules, you can always rely on standard contractual clauses. But I think there is also a very interesting point as European Union can from time to time apply like different mechanisms. And I think the most important and the most famous is of course with US. And there was a safe harbor, which was invalidated by Schrems' first judgment. And then they implemented privacy shield, which was also recently invalidated. And then basically the European Court of Justice highlighted that you should not only rely on those transfer mechanisms from GDPR, but even more, you should apply transfer impact assessment, which is nowhere to find in GDPR. And basically the goal of this transfer impact assessment is to evaluate the laws of the country that you want to make the transfer to, and also evaluate the personal data that will be subjected to this transfer.
So I think pretty much for me, what came out striking in your bill as the fact that transfer impact assessment has to be conducted, which is not a provision of GDPR. So for me, I think that's actually quite a striking view. Okay, so let's move to Sanjeev. Yes, Sanjeev, you have practiced for over 15 years on privacy. You are a certified professional, with your practice geographies covering US, Canada, of course, and Singapore. So can you tell us first, what does cross-border data transfer means to a Singaporean? And in what instances can it, manifest? Please, can you help us check the sound?
Yeah, thank you for the question. Okay, so I just want to share with everyone that in Singapore recently, we had a new data protection obligation being introduced, which is called data portability. So if you want to transfer data out of Singapore, especially of a Singaporean citizen, then you have to accord him or her the same level of protection what he or she would get in Singapore in the country that you're transferring it to, right? Previously, we did not have this obligation. And then also what my fellow panelists have mentioned in Singapore, if you are a group of companies, you have to have in place either corporate binding rules or contractual clauses to be able to move the data from Singapore. And last but not least, I think my fellow panelists also talk about things being in the cloud. So in Singapore, they are very, very clear about it. If you tell the regulators that the data is in the cloud, let me tell you, my dear friends, they will come back and tell you, where is the cloud? And you point to the sky, they will look at you. What have you done to ensure that the data is adequately protected, right? So they're basically looking at your access controls, and they, especially for financial institutions, they have made it mandatory for them to do a penetration and a vulnerability test. And that is every year required. And you cannot just go with any whole cloud service provider. It has to be a reputed one.
Thank you, Sanjeev. Like I would try to point out, what came out striking to me is, of course, the reciprocity requirement. You know, that, of course, if you, whatever would be the process, you know, in Singapore, must be accorded the same level of process, you know, when it comes to transfer of personal data in the other country. So, okay, so let me come back to you, Adavi. Now, when we are looking at the cases of transfer of personal data, the first question I would love to ask is, are there risks, really? Are there risks? Is it just, you know, is it not just that we are trying to hype up some kind of fantasies with some fancy words? Are there risks? And if there are, what are such risks that are existing in this situation?
Okay, let me just quickly say that I think Singapore has gone way ahead of us to actually address one of the risks that I feel is, you know, we should look at, which is like a weak enforcement framework. So essentially what they are doing with data operability, is that what he called it? Sanjeev just mentioned that. What they're saying is, in essence, is you ensure that the data subject has the same level of protection he would usually have in his country available to him outside of the country. So I think what I would say is the weak enforcement framework that would exist when you have a receiving country not having the requisite level of data protection as the country that the information is coming from, and vice versa. So, I mean, if you look at, for example, with respect to the Schrems judgment, you're essentially expected to have a certain standard of protection and cover for data subjects. What I would expect to see is that when data is being transferred, there will be consideration of the regulatory framework that the data is coming from, as well as where it's headed as well. So I think, to be fair, the risks that are inherent in that is essentially exposing data subjects to opportunity where they are not even covered, to be honest. So if you have a more stringent regulation where the data is going to, and for example, around data retention, essentially you're saying to a client or to a data subject on one end, with respect to retention, this is the agreement we have. But when the information is being warehoused in maybe, for example, in the cloud system, they have other parameters by which they are also bound to actually keep that information. So those kind of lapses are things that we should look at, essentially.
So in a way, you quite agree that, one, there are risks, and two, you know, building your position on the position of Sanjeev, I mean, what applies in Singapore is that, look, we need to get a point that, you know, we need to assure that there's such an equal level of protection, you know, of personal data in the other country, or other, you know, jurisdictions, before we can say, yes, let's build a framework that will ensure that where their personal data can get to, they will be afforded the same level of protection they will enjoy in Nigeria.
Take, for example, the African Union and the Malabo Convention. We already have, I mean, we have several countries that have signed, but we also have countries that haven't. So essentially, we have no, framework that essentially can cover, for example, Africa. So I think what you've pointed out is actually what the situation should be. We should ensure that we consider that whatever happens, the data subjects information is given the highest level of protection available. Yes.
It's all right. Thank you, Adobe. So Sonny, I'm coming back to you in Kano right away. And of course, at Paradigm Initiative, you work as a business and human rights officer or at the desk. And now the point is this. To businesses, what are the regulatory and business risks that they are exposed or prone to when we are talking about cross-border, transfer of personal data? What will you identify as regulatory and business risks for businesses?
All right. Thank you once again, Solomon. And so sorry I had to join from another device. I'm having a network challenge. I just want to confirm that I am audible enough and you can hear me.
We can hear you clearly.
Great, thank you. So speaking of risk, the transfer of personal data involves lots of risk. But looking at it from business perspective, like you asked, I would say, of course, you have to start with the biggest elephant in the room, which is the regulatory and legal compliance. So companies that we have like two instruments that speaks to the issue of personal data in Nigeria, which is the NDPR and the NDPR framework. So data transfer happens every day. It happens in business and it's a critical part of businesses. It could happen as a passive or active. One of the panelists has mentioned the use of cloud, which is like one example of a passive transfer of data. So companies that do not adhere to the provisions of the NDPR, of course, are subjected to the risk of legal compliance. And according to the NDPR, this can cost a business about 10 million naira or more. The provision says that 2% or 10 million naira, and the court will choose, or the regulator will choose which one is better. So that's one of the risks. And then second, there is always a reputational risk. Companies that do not have adequate protection for the data, and in the process, this data ended up in the hands of bad actors. That can spell disaster to the company, and it can erode, customer loyalty and trust of the users. And also, that's all about like non-financial aspect of it. Of course, you have to look at the financial risk of the cross-border data transfer as well, which can include like, the increased cost of operations. Of course, for example, SMEs, which are not financially strong as big companies, and they are expected to also adhere to all these provisions and the law. So companies need to source that money and then employ the services of professionals, employ the services of the EPCOs, had to provide additional protection for the data, of course. That requires money. And, that could also be a risk, because if you can't source of money and then provide the adequate data, that can spell disaster to your business. There's also a lot of business opportunities.
Permit me to short clearly.
Okay.
Yes, I actually sought your permission to cut it short because there's something I observed recently. I observed that on the website of my bank, their privacy policy is made compliant to NDPR and GDPR. Now, will you consider that to be surplusage or a requirement of business given the peculiarity of their businesses? What will you say?
So here's the thing, most of business do not. So most of the Nigerian business, I won't say most, but medium and bigger businesses like bank, you mentioned bank, and of course bank is a big business, so do not operate in one jurisdiction. And one of the panelists, I'm not very sure I had you right, had made mention of the white list and the Malabo signatories. So this is what happened. There need to be adequate
I guess we just lost Sonny. Okay, so while we are waiting to have him back, so let's quickly go back to Magdalena. Let me just have you respond to something. So we have in the room professionals, lawyers and non-lawyers who are working in this field, and they are representing. So some of them need to advise their clients on what they need to do. Should they, have been sell their services across Europe? Will you give them a check of things to look at or to actually work on?
May I just remind to mute the
Can we mute Sonny?
Okay, thank you very
Then
much.
we'll get back to him later.
So I would like to start first on the point of applying GDPR to like in Nigeria. I think really general data protection regulation is like the ultimate point of reference. And I think it's like the most like the highest standard in data protection. And many countries are like improving, changing their laws and adopting them to GDPR. And I think there is a lot of value to the business if you apply the highest standard, because then even like national law will change. You have already the highest standards, so like all the costs are there. And I think what I'm missing very often in discussing privacy is that there is value for business in privacy. And I think also that we were discussing the risk connected with transfers. I think there is no like golden rule here. Whatever like personal data you are transferring, the risk will be different. So if you are like dealing with political data and there is like election time, the risks are much higher. If they are just emails, of course, those are like much less sensitive data. But I think with this regard, like talking about transfer risks, I think we need to remember that applying security measures, having a good security in place is a very good practice. And coming back to your question, like what would be the requirements for Nigerian companies if they would like to make a business in Europe? So if you are offering goods or services in Europe, or like you want to monitor behavior of citizens who are in European Union, then GDPR will apply. So first rule will be you need to appoint a representative in Europe. Then, of course, like all the other requirements from GDPR will apply. You will need to have appoint data protection officer. You will need to have register of processing activities. You will need to have data processing agreements. You will need to have data protection impact assessment for the sensitive data. So the list is really, really long. And of course, that will incur additional costs for the companies. But I think also like just looking at the numbers, I think Nigeria is one of the countries having like the highest numbers of entrepreneurs. And I think there is big potential. So probably there is a big return on investment on privacy.
Okay, thank you, Magdalena. And so building on that, let me go straight away to Singapore and have a chat with Sanjeev. Sanjeev, you have actually practiced in US, you're familiar with Canada, you're familiar with Singapore, and a few other jurisdictions. Now, of course, even before Magdalena told us, we know that GDPR gives us the highest level of privacy and data protection compliance, around the world. So which other jurisdiction, particularly the ones you're familiar with, will you say gives us another high level of compliance? Of course, by the way, before you respond, for me, the assurance of reciprocity, which applies in Singapore is a fascinating one for me, which is a high one. So which other jurisdiction will you say has another high level of compliance to privacy, and what are the points for you?
So thank you for the great question. I mean, the other country that I can tell you that is heading towards the same direction as Europe, right, is Australia, right? Australian privacy laws have just been revised, right? And even China for that matter, right? Because now I'm doing some work in China, their privacy laws too are trying to emulate what GDPR is, because that's the gold standard. And just to share with you all, like in Singapore, when you put up your privacy notice, right, to the external world, the law requires you to inform the data subjects how you collect, use, dispose, and store their personal data. So if you are going to store their personal data in some country that no one has heard of, and you do not inform the data subject, you are in violation of the law straight away, right? And I think in Australia, even the rules are much, much tougher and stricter. Like if you have your laptop, and if you are now an Australian citizen, right? And in your laptop, your work laptop, you have got files, and those files contain personal data. The Australian Customs and Immigration Checkpoint have the authority to check whether are you transmitting or taking data of Australians out of the country. Now that's fascinating, because that is taking privacy to the next level, right? Because people can store data on their hard drive and say, okay, I got Solomon, I got Sunny, I got Sanjeev, I got Priscilla, I got whoever, and now I'm leaving Australia. Or even if you're entering Australia, they have the right to check. So to me, Australia, China are going in that direction, right? And the other country that now I'm looking at or working with is India. I think they are in the process of, again, implementing privacy laws, and everyone is trying to follow GDPR because they know if you want to do business with Europe, you have to comply with them. If you don't, you can't.
It's all right, Sanjeev. Of course, we are aware that India is still on their way to enact their personal data protection bill, and of course they had to rework it because it actually had some anomalies when the first bill came up. So yes, let me.
So just sorry, sir. Just to add one more last thing, in Malaysia, if you breach the data protection regulation, it's a criminal offense. The directors of the company are liable for fine plus jail time. So it's very interesting. And just to share with the audience, in South Korea,
Sanjeev, just to clarify, the case in Malaysia you cited, yes, it's criminal. I mean, we have similar provisions in the Data Protection Bill 2020 before the current one, 2022 in Nigeria, that criminalizes some conduct. However, does that make are there options of penalty, whether you have custodial penalty, which is jail term, and option of fine, or it makes it a provision for custodial penalty, which is jail term alone?
It depends on the breach. So if the breach, like what Sunny mentioned, and my fellow panelists, involves sensitive data, like your passport number, your national identity number, or your blood type, then straight away the regulators are going to put you behind bars.
Wow.
They will because fines the companies can pay. They got a lot of money.
Wow.
Right? And what is interesting is that, my friend, I did recently a case in South Korea. And in South Korea, the data protection law states that the DPO is liable to go to jail if the DPO has not put in the processes in place. Now, that is scary because the data protection officer is being held accountable.
Wow. Wow. Well, for me, I think that actually goes to the sensitivity of processing personal data. I really don't know how many of us here have imagined issue of identity theft. Now, you could be in comfort of your room and someone is somewhere in Abuja and stealing in your name. So if we consider that, okay, custodial penalty could be excessive, we may need to have a reconsideration. You know, some persons were in their homes in Philadelphia, in Michigan, and you know, one dude was there in Dubai. You know, we know our brother now, you know, Osh Poppy. And those people, someone was actually, you know, just piling up dollars, hundreds and thousands of dollars in their names. I mean, that can be very serious. Some people actually lock, even here home in Lagos, you've seen people who committed suicide because somebody wiped off just 150,000 naira from their accounts. I mean, people can be as broke as, you know, taking their lives on 150,000 naira. So for me, I mean, the debate will still go on and on whether we should have custodial penalty, you know, or capital penalty for violation of right to personal data. Okay, so at this stage, let me open it up to our participants for our questions. We have our questions written down. We can just take them so that our panelists can respond to some of them as they can. Okay, we have only one question. Okay. So, okay. Okay, so this question, I hope we'll be able to quickly put it where it belongs. I mean, you can see. So the question says, looking at the wave of sophisticated ransomware attack on data protection services, what are the views? Is it views? What are the views and roles of cybersecurity specialists, contrary to the conception of risk management of personal data? So I think the question expects us to focus on the role of the cybersecurity professional. Is that correct? Okay, so yes. Who wants to respond? Okay, Adam.
I guess when you went, okay, this question is going to be hard. So could you read the question again? I didn't actually get what you said.
I think it's the structure.
Yes,
so
the structure.
it's saying, looking at the sophisticated form of ransomware attacks, you know, could be on your database in the office and all of that. That's what are the roles? What will you say are the roles of cybersecurity specialists? Maybe in-house or whether that role is outsourced.
Okay, with respect to cybersecurity, I believe what first and foremost is even identifying what risks actually or what breach has actually occurred. So if you're trying to compare a cybersecurity specialist with an audit, and he said audit and risk.
No, not
oh, so I heard you say audit and risk at some point.
No, it's the risk management.
Oh, okay. So essentially, for me, I believe that the cybersecurity specialist is supposed to identify the areas of breach. And once those areas have been identified, to essentially work out a framework that would mitigate that risk. One thing that we are expected to do from our end as well as data privacy experts is once those situations occur, we are supposed to report those breaches to both the data subjects and the regulators within that particular sphere of influence. So I hope that answers the question. The cybersecurity expert has the responsibility of identifying the risk and then mitigating, and then essentially we end up ensuring that we can do damage control where it comes to managing the information when it gets out to the public.
Okay, thank you. So let's have
May I just add, I think that privacy and cybersecurity are like very connected, and you cannot have privacy without cybersecurity. So privacy is more focused on the data, personal data, what do you have? And cybersecurity is more responsible for like what controls, what security measures you have, how you can, for example, identify that you are dealing with DDoS attacks or different attacks. So I think that's very much connected and
yes.
important.
Thank you, Magdalena. Let me quickly go over to Kano. Sonny, are you still with us? Hello, Sonny. Please can we unmute Sonny?
Yes, I am with you, Solomon.
Okay, great. So Sanjeev raised the point, which is a legal provision in Singapore. And looking at that possibility, I mean, a situation where we may have disparities, not we may have, that we have disparities in our laws, I mean, across jurisdictions. Now, to what extent can we have efficient collaboration, among data protection authorities for the purpose of having seamless cross-border data transfer? To what extent do you think that is possible?
All right, thank you very much. And I think it's not just possible, it's actually very necessary. So the issue of data protection is quite sensitive. I mean, personal data protection in this context, it's quite sensitive, and dealing with data involves lots of stakeholders, from the starting from the data subjects themselves, and then data controller, the authorities, and then licensed organizations that are meant to provide, guidance and oversight, and all that. That is the data protection compliance organization. So you need to, and of course, I need to involve, the human rights defenders, digital rights defenders specifically, which happens to be also big stakeholders in this, because they provide the need for accountability. They push the need for that accountability. So if you have all these, stakeholders, none of them can work in silos. For example, there needs to be a mutual assistantship. Maybe businesses themselves need the services of the DPCOs, and also the Data Protection Authority needs to provide, regulatory landscape to ensure that we have a robust data that speaks to any vulnerability that might arise. So Protection Authority provides the legal and compliance landscape, and then DPCOs kind of provide assistance and technical and non-technical assistance to the business, and then businesses implement, and then human rights defenders kind of provide the need for accountability in that. So I would say there will be that mutual assistantship is necessary. They need to work hand in hand to ensure that people's data is it's quite protected, and it's also good for the businesses as well. We have mentioned the risk that might arise, and I think that relationship is necessary, needs to actually exist to have a robust
so
protection.
We had you loud clear, and what you have told us is that that collaboration is not just possible, it's actually a necessity. But by the way of a party shot this afternoon, you see, Sanjeev actually give us how did we have some severe provisions, severe penalties, for violation of personal data in some jurisdiction. So what will you say, leaning on the position of necessity, you told us, how do we balance that, reality? How do we balance the circumstance that in some countries, Now, my question now is to Sonny. I'll still come over to Sanjeev. So, Sonny, how do we balance that, those realities? When in some jurisdiction, what at best you may have as a violator when you're a data controller is a fine. And in some other situation, maybe some of your directors may have to spend some years, behind the bars. How do we balance it when we are talking about the necessary collaboration you have told us?
I mean, most of the instruments that speaks to data protection tried as much as possible to speak to roles of every stakeholder, what they are going to do. And for example, like you said, balancing the reality with what the law is. So, for example, there is need, maybe when you're transferring data from one jurisdiction to another, there has to have that balance of adequacy. But company by themselves might not know what are those requirements. Then they need to employ the services of the professionals that will work to come up with let's say the to guide them on how to execute the binding corporate rules where necessary, maybe to create data transfer agreement. Maybe when you want to send the data to a jurisdiction that do not have adequate data, you need to have a data agreement, with that. But then you need to have lawyer or DPCOs, compliance authorities, to walk you through all of that. And also in terms of, the provision of the law, for example, let's take the NDPR, and also I think cuts across almost all the instruments. Most of these instruments make it very necessary. For example, the NDPR, if you deals with data of 1,000 and above Nigerians, you need to employ the services of the data protection authorities. They will guide you, they will review your activities and then make recommendations toward compliance. And also, they need to share best practices. So it's not only one-sided. For example, even the companies can help the DPCOs, for example, can help the authority, maybe by sharing information, by keeping them up to date on what are the internal policies or what is the advancement looks like in their space, so that they will have the idea on how to, come up with laws and regulations that will mend any gap that might arise from that development. So I think that's how actually it's balanced.
There, you actually spread the burden, across all stakeholders. That look, it goes beyond the data protection authorities. Businesses need to share their own side of the body and all of that. And I think I agree with you pretty much. Thank you so much for your time this afternoon. So let me go back to Sanjeev in Singapore. Yes, Sanjeev. I think on a very final note, I need you to tell us, what should data protection authorities do or ensure for us to have a seamless transfer of personal data across borders?
That's a very tough question, and in the time given to me, I will try my best. I think what the regulators need to do is that they need to adopt the common sense approach, right? Because whilst we are there to protect the data of data subjects, but I don't think we should go overboard. Because today, I think my fellow panelists would agree, we are living in a borderless world, right? Where data seamlessly moves from one to another. So what my fellow panelists alluded earlier, either you have corporate binding rules or you have contractual clauses. And I think companies must realize, and people, ultimately, we need to protect the privacy of everyone. and it's for the betterment of everyone, right? It's not stifling business, but by having good processes and putting things in place, you are actually going to increase efficiency and enhance your business. So just the last thing I want to say, like in Singapore and Malaysia and even most of the ASEAN countries, they have got a mandatory requirement by law. They have to have a data protection officer as long as you're incorporated in the country. And if you do not appoint one, the regulators will make the director the DPO. And then you are answerable, which no director wants.
It's all right. Thank you so much, Najib. Thank you.
Welcome, sir.
Yes, thank you so much. So, yes, Adabi, I'm actually coming to you. And I want you to capture all of the views. But more importantly, now currently Nigeria doesn't have a data protection act yet. We have, thank God, so but we have one which is an improvement. Now, on the final, what will you see businesses, I mean, generally data controllers in Nigeria do different pending the time we're going to have a data protection act?
Okay, I actually wanted to add something to what they were speaking of with respect to the data protection authorities and what they can do with respect to collaboration. And I'd like to speak to the African continent with respect to the African trade agreement. I feel like Africa has taken the backstage when it comes to data privacy because we have been standard adopters. But the understanding of data privacy here and even the indigenous nature in which we capture data requires us to have a more unified, cohesive approach in actually managing data governance and cross-border transfers. So what I would suggest is that data protection authorities, for example, within this African framework, consider working more closely together to come up with a unified standard approach when it comes to cross-border transfers. In that situation, it makes it easier to speak to other entities, to other European Union, to other countries outside as well. Exactly. That's my take on it. And then with respect to businesses and what they need to do, the truth is that from one of the takeouts from the other sessions is that data privacy is not a response. It actually should form the bedrock of any business. So privacy by design is not just something you just throw around. It's important that any business looking to serve clients, customers, across the globe, consider putting in data privacy compliant framework within their systems as from the startup. It isn't something that we should be responding to from a compliance aspect. It actually drives the market business. So having that approach actually makes it easier for you to identify and target clients appropriately. It actually makes it easier for you to even manage and store data effectively. So that's what I think.
Great. I think that's actually quite consistent with what Magdalena said the other time, that of course, holding yourself to the highest standard possible or available, which is GDPR, it's not just a thing of compliance. It actually shows how you value your customers and your consumers. And of course, for them, it's actually a huge one. So thank you so much for your time, Madam, this afternoon. And over to you, Magdalena. What will be your charge to businesses, data controllers across, Nigeria, across Africa? What challenges will you throw to them?
Well, I think I will rephrase the question a little bit. And I think I would argue that privacy helps to keep your trust and reputation intact. And I think it's something that it's invaluable for any company. So I think there is never I think the hardest thing with everything is just starting. And just, whatever is your current level, just think about privacy. Starting from today, maybe this conference was helpful, and hire a data protection professional. I also I have seen what happened in Europe after the introduction of GDPR, and I think we have much bigger professionalization of data protection
Yes.
professionals.
Mhm.
And I think also there is value for businesses. And I think that's the ultimate value of privacy.
Mm.
Like it can save your business and can help you, because I think people are more and more aware of their data. And of course, like I think there are so many people living in Nigeria and so many smartphones users, and you will have even more of those. And that's amazing market for any business. And I think if you start with privacy today, it will be easier tomorrow. That's my.
Thank you so much, Magdalena. And I think the high point for me is that trust drives, privacy drives trust. You know, when your consumers, all of them as data subjects know that you value their privacy, it actually deepens trust. And of course, they can go all out to patronize your business, your services, and all of that. So, Magdalena, once again, thank you so much for being here all the way from Amsterdam. I mean, this is a huge one for us. Thank you so much. We cannot thank you enough. You've been here since morning. Thank you so much. So we look forward to having you again, next year, for PRIVCON 2020. So
thank you very much. Thank you very much for.
So everyone, we have come to the end of the session. And can we just put us together for our panelists? Okay, that's a great one. So, of course, can we put hands together for ourselves? I mean, you'll be held.